just because something's hard doesn't mean that it shouldn't be the stuff that we're focusing on. The concept of psychosocial risk is far from new, but the dialogue and industry discussion about the topic has elevated since regulatory changes were announced in 2023 and 2024. Psychosocial risk is now the focus of many conversations in the corporate world, from boardrooms to executive teams, and of course through to the practitioners on the ground, trying to join the dots to have meaningful impact. I'm Kate Connors. I'm a master's qualified psychologist, and my professional purpose is to help people and workplaces be at their best.
And I'm Greg Smith. I'm a lawyer who's spent more than 30 years practicing in the areas of employment law and workplace health and safety. I'm also the author of several books, including Paper Safe and the recently published Proving Safety.
And you are listening to Judgemental, when a psychologist and a lawyer walk into a barside chat about psychosocial risk. A big thanks to our sponsor, EML. EML are Australia's largest personal injury claims provider, providing claims management services to workers' compensation, life insurance and CTP markets, with the purpose of helping people get their lives back. We have another jam-packed episode today, so grab a drink and sit back for another discussion at the bar. Well, hello listeners, and welcome again to Judgemental. Thank you so much for joining us, which is our final episode for Series 2. And before Greg and I kick off our conversation, I would like to pay my respects and thanks to the traditional owners of the lands that I am on today, as always, which is the Whadjuk land of the Kulin Nation, and pay my respects. And welcome along again, Greg Smith, to our final chat of Series 2.
Hey, Kate. How you going? You good?
I'm good. Good.
I'm in Perth today. I'm on the lands of the Whadjuk people of the Noongar Nation, and I also would like to pay my respects to their elders past, present, and emerging. So
drink.
Here we go.
We're in the bar.
Oh, okay.
We put the last little activity that we did together, or that I did on our behalf on LinkedIn, was the photo of us together in Melbourne last week in an actual bar. We were in an actual bar.
In an actual bar.
Should we replicate what we drank there, or what are you going to have for this walking into a bar conversation?
To help for people who are wondering, to help close out that picture and give it context, I'll have a Hemingway daiquiri.
Tell us about your interest in Hemingway daiquiris. Where did that arise?
At 9:30 a.m. in Perth, what could possibly go wrong? I always like Hemingway's writing, and I'm a bit of not a fan, that's probably the wrong word, but I'm curious about the history of the man. And he was a famous drinker. And he kind of invented his own daiquiri because he hated sweet things. So he basically took a daiquiri, took all the sweetness out of it. So it's just rum and grapefruit juice, more or less.
There you go.
White rum and grapefruit juice.
Well, to join you, I don't want you feeling too kind of awkward having a cocktail by yourself. I'm going to go a Southside then. It's really not Southside weather here in Melbourne today, but we'll push on regardless.
Oh, has it gotten cold again, has it?
It's not cold, but it's rainy. But anyway, okay. Decision. We are talking, listeners, we're going back to a decision to have a conversation today. And this is a decision that is actually a very recent decision. It was released on the 23rd of September from the Fair Work Commission. And it's an interesting one for a number of reasons. It's kind of connected into reasonable management action. It's connected into bullying conversation. It's connected into working from home arrangements and reasonable accommodation in that kind of area. So I'm going to hand over to you, Mr. Smith, just to give a beautiful summary, high level, the way that lawyers can only do best on this one, and then we'll
very high level
have a chat.
Okay, very high level. It is an anti-bullying application in the Fair Work Commission, and we did have this around when we were doing some of the anti-bullying and reasonable management action conversations, but we didn't rely on it in that context to feed those discussions because as an anti-bullying case or reasonable management action case, it's pretty unremarkable. So there's no novel principles here. There's no novel application to principles. The principles in relation to what bullying are just succinctly stated in the case and they're consistent with all the other cases. The same goes for reasonable management action. And I'll come to it in a moment, but this is a case, I've got a couple of things that stand out for me based on the kinds of things that clients raise concerns with us about. This is more interesting in my view from the points that Kate has picked up, and I'll throw to Kate in a moment. But in very broad terms, there's some very emotive language by the applicant in this case about how they describe their concerns. I'm not going to go through all of that in broad detail, but broadly, there's some issues about his performance. There was an allegation apparently of some misconduct that was never proven. The worker described this as a pretty toxic workplace, which again was never really proven. The allegations of misconduct apparently, and there obviously wasn't much evidence in here because the commission didn't rely on it to much extent, but apparently they weren't proven against the worker, but misconduct, a warning was issued against him. And these issues about performance, he was working from home most of the time. It's not clear how much that fed into the employer's concern, but I get a sense that it must have had something to do with it. But in June 2024, the worker gets put onto a performance management program. It's got a particular name for this employer we don't need to go into, but it's a performance management program. So that's in late June, and then the applicant or the worker takes personal leave from July, and the finding or the evidence in the case, at least to the extent that it was evidence, was that the performance management process, quote, triggered a significant emotional reaction, close quote, from the worker. And then broadly speaking, from sort of July 2024 to about February 2025, when this application was lodged, the applicant only was at work very intermittently and quite unsuccessfully. And there were lots of, Kate and I were talking off air before, reading the sort of subtext, it looks like the employer was going through a lot of their performance management, return to work, medical assessment processes. So there's backwards and forwards about allegations, counter allegations, medical assessments, medical evidence. But ultimately, it gets triggered in February 2025 when he was directed by his employer to submit manual timesheets and of him continuing to be paid for work. And it appears that this formal request is what triggered the concern, and that's what triggered the anti-bullying application.
And I think connected into that, the applicant was concerned in terms of the fact that not only was there that request formally for him to complete timesheets, but the employer was also following what they believed to be medical restriction advice that he should only be working 3 days, whereas he was, and therefore he was experiencing financial reduction from his full-time wage as a response to that. And so I think that there was also then that financial kind of consequence that led to him submitting the application from reading through the lines.
But again, factually, if we talk about the sorts of cases we often see that trigger anti-bullying applications, there's nothing particularly unusual about this. Whatever the minutiae of this case was, there's nothing particularly unusual about performance management concerns about the workplace interacting, getting us to a point where a worker ends up bringing an anti-bullying case. Now, whether that's the worker deflecting in the performance management process, or whether that is the worker legitimately frustrated about the process, not really important to understand. But as a set of facts, leaving aside, as I say, the detail and the minutiae, there's nothing particularly unusual going on here. But Kate, something did catch your eye.
Yeah, there are a couple of things that caught my eye on reading the decision that I thought they struck my attention, right? And that's what this is all about. There were a couple of procedural ones, Greg, which I was curious to ask you about. So the commissioner states in the decision that there were papers only submitted and that there was no hearing. Why would that be decided? Like, when does that happen? Why does that happen in terms of there not being a hearing and that the commissioner has made his determination based purely on paperwork?
Yeah, it's not particularly usual.
Right.
It's simply the commission saying, well, there's nothing really here that turns on findings of credibility of witnesses or anything like that. There's not a lot of witnesses. It is simply a case of, here's the alleged behaviour, and so I can decide that on the written submissions and the statements of the parties that have been filed. It's and normally it's done by the consent of the parties. So the parties agree to have the matter resolved on the papers.
Because it struck me, because I do think that in these situations, particularly the applicant would be in an emotional state where I could imagine they would want to be heard. They would want to tell their story. They would want to be in a hearing. Do you know what I mean?
Yeah.
And in the context of that, aligned with your comment in the introduction around the emotive nature of some of the statements that were made by the applicant that are contained in the decision as well. To me, there is a broad sense that this is someone who did want to tell their story, want to be heard, and it just struck me is all that, because none of the other ones that we've kind of read had that statement in them. So I was curious about that. And there was also a statement made in terms of in the decision around the applicant that the worker was not entitled to apply to the commission for orders on paragraph 5, and then that paragraph finishes with the application will be dismissed. Can you explain a little bit more? And sorry, I haven't given you any. That's a question without notice in terms of the legal process attached to that. But that struck me as well. What's that about?
So ordinarily in a stop bullying case, if bullying is proved, the party can apply for orders in relation that the commission ought to make to stop the bullying. So that it's not just the commission who just goes and acts and says, this is what we're going to do to stop this occurring. They could ask the commission to make certain orders about, it might include things of working in a different office or...
I get it. So ultimately, yeah.
Because bullying wasn't found, then...
Gotcha. Okay.
Yeah, you're not entitled to apply for the orders to stop the bullying.
Got it. So because, yeah, to me that confused me a little bit because it appeared early in the decision at paragraph 5, but ultimately what the commission is doing is referencing the fact that his determination was that the finding of bullying wasn't substantiated, i.e. there was no bullying, therefore the next step of that doesn't apply. Is that right?
So what the commission has done is said at paragraph 5, the bullying didn't occur.
Yeah. Gotcha.
Therefore, you can't apply to stop bullying, so I'm going to dismiss the application, and then goes on to say, this is why I've made the decision I've made.
Yeah. Roger. Okay. So then more into the psychological or the human kind of pieces that really stood out to me as I read this decision. And this was something that when we talked off air that you thought was a fascinating little description as well, was the way that it was described by a psychiatrist in one of the psychiatric reports or review reports, that the applicant had an idiosyncratic personalised belief system, and that these perceptions, thoughts and beliefs, objectively, these were not reasonable. And when I read that, it really struck me to see someone in writing had said that what someone thinks, feels and believes is reasonable And it struck me for a couple of different reasons. One, because certainly within the harassment, the sexual harassment kind of context, that idea that's out there very much in the market is if someone believes or feels that that they've experienced something that is harassing or upsetting to them, then full stop. It is therefore kind of harassment. But separate to that, it struck me that really it's only psychiatrists and commissioners that within the context of our professions that are allowed to say what someone thinks, feels or believes is unreasonable. So I just thought those three things stood out to me as really different to the way that certainly as a psychologist I would go about my work primarily. So what did you think when I kind of shared that with you and when you read that?
Well, I didn't think anything because courts are always telling people their beliefs are unreasonable or mistaken or wrong.
Isn't that in and of itself fascinating? That it struck me like so much when I read it and you were like, oh yeah.
I spend my whole life being told by judges that I'm mistaken. And I think and again, this is an overlap we've talked about a lot. As objectively as, and we don't know the answer in this case, all right? But as objectively as it might seem that somebody's beliefs are unreasonable, that is not the same thing as saying that A, they don't genuinely believe those things, and B, that those beliefs have not caused them harm.
Which is right back where it almost like our first episode. Remember when we talked about that in the very, very first episode, this difference between what people think or feel and whether there is then a sense that in these regulated kind of contexts, whether that fits the context in a reasonable way and therefore a judgment. Coming back to the role of the commissioner and the judges and our title for these conversations is that therefore judgments made, rulings made.
Yeah. And I know you want to talk about organisational justice, and it just occurs to me in that context that we often mistake what we perceive as an unreasonable belief with dishonesty. Well, it's like, well, what you're saying to me, Kate, is unreasonable. You couldn't possibly really believe that. So you're just saying that to try and deflect this process or try and avoid the process. I think there's a lot of, and we see that, you see that in internal investigations all the time, this idea that there is a single source of truth.
Well, I think that's the thing, isn't it? Yeah, it's about whether it's reasonable or not, it's whether you're telling the truth or not and whether what you're saying, your truth matches my truth.
Well, there's two parts to that. There are two things. One is, if it is unreasonable, we're more likely to think it's dishonest. I think that's a perception. And I think that's compounded by this idea, and I think lawyers are probably to blame to some extent, but it's certainly picked up and run within organisations. This idea that if we have a he said, she said moment, that we can't, either somebody has to be lying or we can't determine the truth. And the reality is both people could be telling the truth, both in terms of what they thought they saw, what they thought they heard, what they thought they perceived. And the adversarial, unsophisticated nature of a lot of internal workplace investigations doesn't leave much room for that nuance. And I think when we see these sorts of issues that are often raised just as a sort of mid-level concern, escalate to something really problematic, it's because we can't sort of perceive the nuance of the complaint, and the reality is that most people might be being honest,
truthful and honest.
And we don't have a lot of good opportunities. Again, and I know I've whingered about this a lot in every series and probably every episode. We don't have a good systemic way of bringing people together to try and just recognize that both of them might be a bit right and a bit wrong. We tend to tip over straight into that adversarial process of investigation, witness statement.
That's probably a good segue into a couple of the other points that really stood out to me on reading this particular decision. And one is this thing that comes out a lot, and I want us to talk about this because it happens so much. this thing that is the allegation is not substantiated, yet a warning was issued, which is something that happened in the circumstances of this gentleman's history in the workplaces. Talk to me about that, right? So if something is not substantiated, a human's experience of that, back to your point, is that you're telling me that you don't believe me, right? That's at the core of when somebody says back to someone who's put in an allegation, look, it hasn't been substantiated, it's not substantiated. So then that person is left with that emotion and that experience. But what about this next step that often does happen, but still an organisation issues a warning? So that to me sounds contradictory.
So this one was a bit slightly different from what you've described. This was the allegation of misconduct was against the worker, and that allegation wasn't substantiated. So it wasn't a case of not believing the worker. So here's an allegation of misconduct against you. We couldn't substantiate it, but we're still going to issue you with a warning.
Yes, absolutely.
It's really hard to form a view about that when we don't know what the allegation was. We don't know what not substantiated means, and we don't know what the warning was. So, it could have been, and this is not uncommon, there's an allegation against a worker. The worker refused to participate in any investigation or be involved. The investigation comes down and says, look, we can't really substantiate this, particularly if the person's not involved. And they issue a warning to the worker saying it's not substantiated, but you're on notice that you are required to participate in these processes in the future. I've seen that before now. There's better ways to deal with it than that, but that does happen. But yes, it is jarring when you see those sorts of issues where something has been found, well, this isn't substantiated, but we're going to issue a warning. And very often the warning is not, and I can't talk universally, this is just my experience, the warning is not in relation to the allegations, it's relating to something surrounding the allegations that came out as part of
Right. Okay.
part of the inquiry into that.
It's just everywhere. It happens a lot, right? And I put myself in the shoes of not only the person who has put in a complaint about an alleged behaviour, but also the person that then is the person who's being accused of something, when both parties in that would feel like the organisational justice system is confusing, doesn't kind of make sense, isn't kind of satisfying in the sense of that it feels as though it's doing what people, I think, would hope that a justice experience would provide for them in a workplace.
No, I was going to say, well, when you think back to the last case we did in relation to the sexual harassment matter, when the worker who made the sexual harassment complaint was originally told they couldn't make a finding, and then that was changed and said we couldn't substantiate all the findings. We've spoken to the worker about their behaviour and made them redo the code of conduct course or whatever. I think it creates an enormous amount of uncertainty that says, well, hang on, what is it that you found?
But also, who are we? To me, I take it to a bigger point in terms of, and I think that I don't think individual employees are particularly good at being able to articulate what it is inside that is happening for them, that is causing them distress, and that it is therefore leading to a situation where they are sitting in high negative emotion, which places them more at risk of a psychological injury, if I can kind of follow that kind of mechanism, right? Because ultimately the people who I have always supported or been a trusted, advisor for, as I've said before, in both camps of this, like both the people who have experienced something or the people who have been accused of something, the key psychological kind of thing that's happening for them is how this anchors back into who the organisation is and how the organisation lives up to what it says it is. It's a moment that matters so pivotally in the context of trust, in terms of the values of the place, in terms of, is this all smoke and mirrors, in terms of how an organisation says that it places a priority on well-being and mental health, and yet then look at what's happening here, right? So it creates this quite significant moment of a sense of incongruency in terms of, for both parties. And it just has always kind of saddened me to observe such profound psychological distress and harm to both parties in terms of these processes that happen in organisations. And I think that takes me to my next point, which is the key one that I wanted to raise around organisational justice as a hazard, in the sense of when I'm out workplaces at the moment, and I'm not sure about what you're saying, Greg, but it's not common to see organisational justice in the top 4 or 5 psychosocial hazards on a risk register when people are doing this work. Yet it is when the impact does happen, it is so profound. So in terms of the harm and in terms of the severity, and then in terms of thinking through catastrophic consequence, organisational injustice is really one of the most important anchors, I think, for so many other elements of how people experience their workplace. And it just doesn't seem to me to be getting the degree of focus in the context of all of the expectation around, assess the risk, control, because it's the people who have experienced these processes. They don't want to talk about it, and they're also in the minority. So through the consultation processes, it wouldn't be coming up. Yet that doesn't mean that in the context of where real risk lies, that it's not there, and could be absolutely could be the trigger for some of the most catastrophic outcomes is in this space. So that was the other reason why really it struck me, this organisational justice, organisational injustice as a hazard. And it's just not, from what I'm seeing in the market, at that enterprise risk level, getting the attention that I think it warrants. I'm not sure what your thoughts are on that big tirade of.
I think one thing it does, it speaks very much to the interconnectedness of these types of issues. I mean, you can see it in every aspect of working relationships. So if I have a process for saying, if you want, if you need to apply to work from home for whatever reason.
Yeah, let's use that.
Right?
That's a good idea. Yep.
And you just say, okay, so here's our process. If you want to work from home or, for a period of time, or you need to adjust your working days or hours for a period of time or whatever it looked like. And I'm going to I make that application and I feel the organisation's just gone through the motions and I don't feel that I've been heard, rightly or wrongly. I think that failure to be heard, I would put that in the bucket of organisational justice as well.
Absolutely.
You've said, here's the process. I'm entitled to access the process.
Yes.
And you're not giving me a proper hearing.
Yep.
In inverted commas, in the process. So there's an interconnectedness to all of it. But I think we have this problem that organisations set themselves up for failure. And a lot of it has to do with the disingenuousness of corporate speak. And I hate this to the marrow of my bones when we talk about workplaces as families. And I won't swear on this one. I swore on the last one. I've got to edit it out. It just drives me nuts because you're setting yourselves up for failure. You're making promises you have no capacity to keep. Where I first sort of really started running into this outside of employment, which I found interesting, was, and I could go on a bit about this too, but safety incident investigation. And organisations say, we share lessons from incidents and we want to learn and we're very concerned about safety. Until something goes badly wrong, and then you cover it with lawyers and you put it under legal privilege and you never talk about it to anybody. And the negative impact that can have on a workforce is really, I'm not saying it's the wrong thing to do legally, but the impact it can have on your organisation can be quite dramatic. And the other area I think where this really stands out is whistleblowing programs, where people set up their whistleblower programs and the poor old whistleblower ends up becoming quite victimised in some cases. And so, yeah, it is a problem. But I think a case like this, where, and I don't know how you find the balance. This is the very practical issue. I mean, I can draw you the legal flowchart, but where you find the practical balance can be a little bit more problematic, is when, as in this case, objectively somebody's concerns are so objectively unsubstantiated and unreasonable but genuinely held. How do you provide a sense of organisational justice to that person?
Yeah, no, I think you're right, because ultimately I think that this is where I would go to, well, there is the difference between the process and the content with which and how the organisation is then interacting with someone, which again, in this case, the commissioner's decision clearly says there is evidence that the employer was trying to support, was in contact, was frequently checking in, like all of the stuff that is the good practice, which is ultimately, if someone is angry with you as an employer, you need to find some vehicle or someone who can maintain contact and a relationship, because you still need to, even if there is an inherent disagreement with an outcome, you still need to be able to be in dialogue, right? As the formal process of taking it potentially all the way through to the commission or whatever might need to happen for an outcome to be determined. And that's not necessarily then saying that person will be going, oh, okay, now that the commission said this, then that must be right, because that's not what happens. People still go, well, that's still not fair, but they've just got no avenue left to go. And the bouncing ball, to your point, has stopped. But back to your earlier point in terms of the intersectionality of organisational justice, and it's also kind of got this, I think at a practical level, it's almost got like an amplification impact on other hazards. So, for example, reward and recognition. So if someone is promoted above someone else and that feels to other people in the team that that's not fair or that's not right, the ripple effect of that, which technically that, could be allocated into, well, that's our recognition and reward kind of systems that need to be conscious of that. But actually, it's got a total interface back into organisational justice, or an intersection, an amplification. Role clarity is another one. Work delegation then has an impact on work demands as a hazard, because sometimes people people perceive that there is preferential treatment in terms of somebody getting access to better kind of options with work or different privileges attached to work. So that's got that, again, that amplification and intersection into work demands. Someone might get more work demands or less work demands. But also then in terms of the clarity, if someone has a job description and clearly somebody is supposed to be the person that's their job, and yet, that's being circumvented for whatever reason. Again, amplification, confusion on role. So you can see, I think, why when I'm, as risk registers and more exposure and hearing more conversation, etc., and all of these things continue to gain momentum. And particularly, obviously, I'm in Melbourne, so that's more of what I'm seeing, and people are doing a lot more prep at the moment with the regs launching on 1 December. Yeah, I don't know. I just, all the clients I speak to, I would say this, but I just thought I would provide some free advisory advice to any employers listening, that I do believe that this point around organisational justice, if it's not something that you are strategically focused on as a hazard, within, in the context of your risk register or whatever, then I would really encourage people to think about it, because I do think it is one of the key ones that has a very significant amplification effect and takes something into, just almost like a kind of moderate risk into the catastrophic kind of area in terms of human outcomes for people.
But part of the response to a call like that in lots of organisations would be a grievance procedure.
Yeah, so let's not do that. There's some more free advisory. Let's not try and process our way through something. Let's try to actually take a step back and be strategic and look at what our system actually is, and look at how much we are doing what we say and saying what we do, and look at how we're providing the right kind of space and time and development for our leaders to be the leaders we need them to be and want them to be. Like, it is a big step back in terms of what some of the key barriers are that lead to these experiences happening. But, just because something's hard doesn't mean that it shouldn't be the stuff that we're focusing on.
Or we could just have a grievance procedure.
Mr. Smith, what a beautiful little, but but you're distilling what happens. You know what's just happened in my brain? And there was, I've just seen this cartoon. There's this really funny cartoon, and if I can find it, we should probably post it with the link to this episode when it gets released. But it's a cartoon, and it's got a sign, and the sign says the easy way. And there's this huge big queue of people lining up for the sign that says the easy way, and the sign that says the right way has only got one person, this lone person kind of following that sign. And I think that is at the essence of the complexity attached to how organisations, kind of approaching this sometimes.
People who work in work health and safety will be familiar with that. We have a concept in the safety industry of just culture, and it's quite a proceduralized. It's this idea that it sort of comes out of the human error and no blame research and thinking around safety. And it's designed to say, look, people are going to make mistakes. You have to look beyond the fact that they've made mistakes. You have to look at systemic error. And you've got this just culture model, which kind of says, starts at one end with deliberate sabotage and works all the way people make mistakes. And it's designed to help in disciplined decision making. And it's this idea that we've got a process that we put a framework in place so that we don't jump to the conclusion that you made a mistake, therefore you do the wrong thing and your employment should be terminated. We ask a series of questions. And again, this is anytime you talk about organisational culture, just culture, whatever, even risk assessments, as soon as you proceduralise something, one of the risks, and this is organisational corruption, which I talk about a bit, you need to understand that it has the potential to be undermined. And we see in the health and safety world that just culture is now being described as something that is being done to people. I've just been just cultured. We're going to just culture you, sort of thing. And it's used to achieve the outcome that you wanted to achieve anyway. So say, this is the outcome I want. I'll slap the template on it. I stop at the outcome I want, and that's what I get.
And that's injustice. That's at the core of when humans will have that kind of, this isn't fair. And at a psychological level, one of the core cognitive beliefs that can create extreme distress and keep people stuck for years is when something doesn't feel fair. Now, absolutely, there's a whole treatment regime and thoughts around how you support people who do have that cognitive kind of loop happening in their head that it's not fair, it's not fair, it's not fair, because life isn't fair ultimately. But it doesn't undermine or dismiss the reality that we're kind of wired. Humans are wired for a sense of fairness in some way.
Mm. Well, it's interesting because in the decision we've been talking about, the allegation by the employer was that the department has adopted a process as punishment methodology. And I think I think that's a very real thing. And
It's ass covering.
well, I think in this case it was alleged to be a bit more than ass covering, but it is God, I hate using the same language, but I think it describes it. Once it gets perceived as mechanistic, it becomes much more difficult to imbue a sense of organisational justice, and to have people genuinely believe that's what's going on. Again, this is my fear. I've expressed this from day one. Overtly bringing psychosocial risk into the work health and safety regime, I think we do run a real risk of the application of mechanistic process to psychosocial risk in the same way we see the application of mechanistic process to workplace health and safety risks. And in some ways that's almost a necessary byproduct of the risk assessment process. So we've talked about the problem with risk assessment and psychosocial risk. But one of the difficulties, of course, is the risk assessment process inexorably leads to the development of controls. And that inevitably leads to some sort of proceduralization of response.
Yeah, I'm not sure it inevitably leads to. I think the way that workplace health and safety practitioners have been trained to do it, it probably more inevitably leads to that. But I think if we try to, and we don't know yet, right? My advice is we'll make sure that within that controls kind of language and documentation, that strategic interventions are also detailed, and strategic interventions and cultural priorities and how they are being embedded, prioritised, rewarded. That's meaningful control for a lot of this.
Yeah. Okay. Now it's starting to drift dangerously into the area of irreducible uncertainty when you're starting to talk about proceduralizing or documenting all of those variables. And perhaps, and I know we've talked about this before, but perhaps the real opportunity here is to actually put more tripwires and discretion into our process. Say, oh, hang on, stop, turn that off. We're not going to go down the path that we've said in our procedures, and here's why we're not, and this is what allows us to do it. And that almost that triage type model that we've spoken about before, and communities of care that we've spoken about.
Or it's both, right? To address that legal kind of concern about the sense of uncertainty. But I think from a meaningfulness perspective, strategic people programs and strategic transformation and change in certain areas is certainly still relevant in the broader scheme of bringing in effective and tangible change without it having to have a process.
I look back on my career and I wonder how many damaged work relationships could have been salvaged if we had the capacity to turn off our grievance procedure at some point and say, well, how do we resolve it?
Well, I'm conscious of time, and I'm also conscious that...
Oh, you stole my line.
I know. If we were to do a tally on who said that the most, it's usually you.
It'd be me.
But yeah, so this is our final ep to use the podcast vernacular for series 2. What was your highlight? What was your favourite ep, Greg? Again, question without notice.
Oh, the one where we were in real life in Melbourne.
The one with Keith.
Yeah, with Keith. Yeah.
The white paper. Inside the minds of Australia's workplaces one. Okay.
Yes, I really enjoyed that.
Yeah, mine was our chat with Amy.
Oh yeah.
The vicarious trauma chat. That
was
my favourite.
That was a good one, wasn't
it? Yeah. So anyway.
God, that seems a long time ago.
Well, by all means, send us a little note or reach out to Greg or I on LinkedIn if you'd like to share which was your favourite episode or any ideas for the future. At this point, we're herculating the idea of Series 3, having a structure where we do episodes on how employers are practically addressing and putting in control mechanisms, which is an interesting thing for us to say after that last discussion on particular psychosocial hazards, getting some employers in for some conversations. That's an idea that we're kind of playing with at the moment. So please let us know if that sounds of interest. And obviously we will continue to make sure that we have conversations on any different decisions or reports and things that come out that seem really important as part of this conversation too. So thank you, Greg.
And keep an eye on LinkedIn.
Oh, yes.
That's all right, Kay. I was just going to say, keep an eye on LinkedIn because there might be a fun event coming up.
There might be. We're in discussion around possibly taking the
Don't tell. No.
Yeah, well, okay, shush. No, okay, fine. But keep an eye on LinkedIn. We'll wait and see.
Keep an eye on LinkedIn. Thanks, everybody. Thanks for listening in, and thank you, Kate.
Thanks, everyone.
Good to talk. Bye.
Cheers, Greg. Chat soon. That's a wrap for another episode of Judgemental. Thanks again to our sponsors, EML. EML's Mutual Benefits Program provides organisations with free services, tools and resources to manage their workplace risk. You can follow EML, myself and Greg on LinkedIn, and be sure to check the show notes for links to the papers referenced in each episode, as well as resources available to help you as you navigate the wonderfully complex and nuanced world of psychosocial risk. See you again next time at the bar.